in certain instances they can, and an association has to be very, very careful because they're sometimes you have boards that think that because they have a restricted community in and of itself, because you have governing documents, that they can restrict everything from tenancies to the sale of the home. And under certain circumstances, they may be able to restrict it. The first thing that I would point out is that an association has to be very, very careful not to violate any federal or state housing laws. So if you start restricting and discriminating against persons because you want to have a certain type of person that lives in an association, and you want to exclude other people, and those exclusions are illegal federal housing acts and Florida Fair Housing Acts, you can have issues with that, big issues, and those may involve civil penalties, but if they're done in a malicious way, they certainly could involve other penalties as well. And certainly punitive damages could be out there as well. So an association has to be extremely careful with that. One of the issues that comes up is that associations try and restrict sales to individuals with certain criminal background problems or to certain civil issues, such as bankruptcies or credit issues. I think with the bankruptcy and credit issues, I've seen those in documents. I have yet to see a battle where that's been fought. And I really think that the associations would lose on that front if you're trying to restrict it to a sale of somebody because you're saying, well, they may not be able to pay their assessments because they claim bankruptcy, which, you know, as a practical matter is nonsense. So I think that those would not survive. The more questionable issue is whether or not a unit owner can sell to somebody that has some type of criminal background. So upon the sale, the declaration says that you have to submit the application of the new purchaser to the board for approval, and they do a background check, and they say, oh, well, he's been convicted of certain crimes, so we're not going to allow that sale. The governing case law to date, and it shifts, so you have to be careful. But the case law that's in place now really focuses in on the language that is in the declaration that would be used to restrict a potential sale or a potential buyer based upon criminal record. And so if you're going to say anybody with a criminal record, I think that the association is going to lose that battle. If it restricts it to certain felonies, then the association's getting closer, but I think it needs to spell out what kind of felonies, and they need to be reasonably tied to the safety of the neighborhood. So I think if you're going to say, well, we're going to restrict it, can't sell it to people that have convictions and have been listed as sexual predators, then that may be able to be enforced. But as a general rule, if you're just saying, no, we don't want anybody in here with criminal or civil kind of payment issues, the association is going to lose on that. So they can restrict it, sales, but they have to be careful that they don't run afoul of any federal or state housing laws or acts. And then they need to make sure that if they're trying to restrict it based upon the background of the potential buyer, but not based on any kind of you know, race or creed or religion, things of that nature, but based upon the background of their criminal or their civil actions against them, then it's possible to do, but you have to be very, very specific, and those have to be reasonable restrictions. So it's kind of a dangerous area for associations to tread into, but there are some of those, if they're drafted correctly, that can be enforced.